114217, 114220, and 114222. State of Texas versus Virginia Cerna. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Michael DeLeon for Ms. Cerna.
And are you Ms. Cerna?
Yes, ma'am.
We are here, counsel, for a bond reduction. Is that correct?
That's correct. Just for the record, Your Honor, originally Ms. Cerna was charged with aggravated assault with a deadly weapon. Her bond was set at $15,000. That occurred early in 2023. She, in late October of 2023, picked up 3 charges of aggravated robbery, which we very much dispute. And because of those robbery charges, her original bond on aggravated assault was remanded without bond. Okay. So today we're going to.
Just one moment. And the court will also be calling 2023 CR 5815. You may continue, counsel.
And today, Judge, we're going to be asking that a bond be set in her aggravated assault charge, and the associated aggravated robberies are set at $75,000, which is highly excessive. Before we go to the facts of those aggravated robberies, we're going to be asking for a bond of $10,000 each on the aggravated robberies, given the circumstances.
All right. And what bond would you be asking for on the aggravated assault?
It would be ideal to reinstate her bond at $15,000, but we will go with whatever the court wishes to do.
All right. And state, are you prepared to proceed?
Yes, ma'am. We're ready.
Any witnesses? State or defense?
I mean,
None, Your Honor. I do have, I'd like to give the court a packet. I can do it one or two ways, either, and I've shown this to Mr. Wilkins, series of pictures, and I've marked it as defense exhibit number 1. I can have my client identify it, or as an officer of the court, I can identify what those pictures are.
All right. Any objections to defense exhibit number 1?
no objection, Your Honor.
All right. Then the court will set exception to evidence defendants exhibit number 1.
And if I may, Your Honor, what the court is looking at in defense exhibit number 1 is the first photos are of the 3 complainants in the case. The very first picture is Christopher Cooper, who is the biological son of my client. He was not raised by Ms. Cerna, but they are biological. And the other 2 are friends of Mr. Cooper. Additionally, you're also seeing social media posts of the various complainants and their various photos with weapons, with smoking blunts, with putting up wads of cash with those weapons as well. And lastly, there are injuries to Ms. Cerna's arm that occurred during that robbery. And we do want to address that when we get to that point. But that very last photo is a kind of fresh photo, and it's kind of hard to see in the black and white versus color, but she was cut by one of the complainants.
The court sees defense exhibit 1 with the alleged complainant listed. The court sees what appears to be the complainants holding AK-47s and Glocks.
Yes.
And then the next photo appears to be the complainant, who is the defendant's son, holding cash, wearing pants that are 30 sizes too big, that are sagging. Then the next photo appears to be 2 complainants with someone with a gun, but there is no face to the person holding the gun, pointing the gun at them as they smoke blunts and photograph the person pointing the gun at them. Then the next photo appears to be someone holding a gun. And I believe that's the complainant that is listed on page 3 of defendant's exhibit number 1. And then the court sees photographs with no face. So I don't know, I'm taking you at your word saying this is your complainant, but there's no face, but it appears there's no talking by you unless you're under oath. But I do see photographs that appear to match the mark that's on your client's arm. But again, her face is not pictured in defense exhibit number 1.
As an officer of the court, I will say that I've talked to my client she has identified the three complainants, that being Jonathan, Joseph, and Christopher being the ones in the photos. And I'll also point out to the court that these photos taken from social media were my client got those while she was out on bond, and was able to forward that to me before she was taken into custody on these new aggravated robbery charges.
Okay.
Additionally, Judge, if you look at the facts and circumstances of the case, I know we're not here to litigate the entire aggravated robberies, but there's an allegation that Ms. Cerna and her husband pulled out guns after inviting her biological son and his friends over to a La Quinta to see a just under 2-year-old stepsister that was born that Mr. Christopher Cooper has never met before. Suddenly a robbery occurs allegedly with firearms by Ms. Cerna and her husband allegedly. However, if you look at the facts and circumstances again, La Quinta management throws out everybody out of the hotel. There's an argument going out in the parking lot when supposedly my client and her husband have firearms, yet somehow these complainants are hanging around in the parking lot with them when they've just been threatened with firearms. Doesn't make a lot of sense. Additionally, Ms. Cerna does have that injury to her arm. She was cut. Once again, if she had a firearm, she wouldn't be in the position to be cut by Jonathan Vidales, who is in fact, all of these are, well, actually, Jonathan and Joseph are juveniles. Mr. Cooper is, I believe, 18 years of age at the time of this event in October of last year. But the circumstances are very suspect, Judge. So without going in, and obviously this court is not going to make a judgment on the veracity of if she's guilty or not guilty of those specific aggravated robbery charges. But given the circumstances for setting a bond, we believe that because of the nature of the weirdness, essentially, of this allegation, we're asking that bonds be set of $10,000 on the aggravated robberies so they can be litigated down the road. And we'll see further in the future if, and this case is unindicted. These three charges have been unindicted for the past roughly 60 to 90 days. We will see if the district attorney's office will even go forward. I mean, obviously, Mr. Wilkins might know more about if they even have complainants that are going to be continuing to complain in the future. So based on that, Your Honor, and the circumstances, we're asking that the bond be set on the aggravated assault and a much lowered bond be set on the aggravated robberies. Obviously, if the court wants to do GPS, that is more than fine. We might ask the court to reduce or waive GPS fees, but if the court wishes to do that, we need more. Ms. Cerna will certainly comply with all GPS conditions.
All right. State.
Yes, Your Honor. We are asking that you double the bond on the aggravated assault deadly weapon from $15,000 to $30,000. And we're asking that on the aggravated robberies, that you keep the bonds at $75,000 each. We're also asking that you, she has these conditions of bond, the special conditions of bond, Judge, that I attended to the court. We're asking that you keep the GPS with full house arrest in place, no contact with the complainant witnesses in the aggravated robberies, Jonathan Vidales, Joseph Berrientos, and Christopher Cooper. A prohibition on possessing firearms. And Judge, I've previously tendered to the court the police report. I didn't mark those. I have stickers here if you'd like.
If you mark those as states exhibits 1, 2, and 3.
Yes, sir.
And defense, have you had a chance to review those documents?
We have, Your Honor, no objection.
All right, then states exhibits 1, 2, and 3 are admitted. And of course, defendants exhibit number 1 is admitted. And you can tender those to the court reporter. I've reviewed those.
Okay, yes, ma'am. So just
And I'm sorry, just so the record can be clear, those were reviewed before they were offered into evidence, and both the defense and the state requested that the court review those before they were offered into evidence.
Objection.
Just real briefly, the argument. In the police report, these are very serious allegations. We're asking that the bond be set at this high, or kept at this high number in order to protect the community. code says that you can set reasonable conditions of bond. We think under the facts alleged in this police report, these are reasonable conditions, this amount, as well as your full house arrest GPS. And if you were inclined to grant a lower amount of bond, we would still ask for the other conditions, the full house arrest GPS, Judge. But I reviewed those pictures, and I think some of the questions that maybe the court had too. You know, this is a picture. I don't really know what this is depicting. This could be an airsoft gun. This could be a real gun. These guys could be engaging in blunting, or this could be tobacco. A couple of these guys are juveniles, so they have guns in these pictures that are undated. I think we don't know when that is. I don't think any allegation that at the time of the offense, October 27th of 2023, that any of the complaining witnesses had guns at the time. That's not in any of the police reports. So, Your Honor, in order to protect the community, we are asking for those bond amounts as well as the full house arrest GPS, Your Honor.
And lastly, Judge, if I may,
Yes.
what I forgot to mention was nowhere in that police report does it say that anyone beyond the complainant said that Ms. Cerna and her husband had firearms. The hotel manager was told she had a firearm, but never saw it. So I want to be real specific about that.
And just briefly, I mean, when I was reading the police report, if you're in a hotel room, I don't typically invite the manager into the hotel room. So I don't know how we would see if there are guns or not in there.
This is as everyone was exiting, all the parties.
Okay. So is there anything else from either side?
There's a few more things. No, I'm just kidding.
All right. So I'm going to keep the previous conditions of full GPS. I'll ask that the fees be waived. For the aggravated assault with a deadly weapon, I'm going to set the bond at $25,000. And that is cause number 2023 CR 5815 and CM number 114217. The court will reduce the bond to $60,000. And that's based upon what the court has reviewed in the police report. And cause number CM 114220, the court will reduce the bond to $60,000. And in cause number CM 114222, the court will reduce the bond to $60,000. And there's to be no contact with, is your husband Ruben Cerna?
Yes, ma'am.
There's to be no contact with Ruben Cerna. All right. Is there anything else?
Nothing, Your Honor. Thank you.
All right, Ms. Ferguson, we need a jury trial date, a quick date on this case. State, how long do you expect this trial to last?
3 days, Judge.
All right. So that means it'll probably be 2 days. The earliest date you have. All right, we'll come back with jury trial on February 6th. If you're still in custody, you will be brought over in trial dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something else, you'll need to do a clothing exchange. Mr. DeLeon, if there's an issue with the clothing exchange, let the court know.
Yes, Your Honor. We thank the court.
All right. And do you know if your client will be going, if she were found guilty, do you know if she'd be going to the court for punishment or the jury?
We haven't discussed that yet, Your Honor, but probably the court.
All right. On Eric Lopez, court is calling 2023 CR 1326, State of Texas versus Leslie Cox. Can I have parties announced for the record for the state criminal trial division?
Hank Wilkins for the state, Your Honor.
Defense,
Luis Martinez on behalf of Ms. Cox.
are you Miss Cox?
Yes, ma'am.
All right. And you always address appropriately for court. I appreciate that. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Judge, I did.
Court will find that the state is in compliance with discovery. Ms. Cox, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Judge.
Showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We're proceeding under the lesser included offense of Class A misdemeanor DWI with the BAC above 0.15.
Any objection?
None.
Going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand that the state is proceeding on the lesser included of driving while intoxicated with a result of 0.15 or more? As a Class A misdemeanor, the range of punishment is up to 1 year in the Bear County Jail and up to a $4,000 fine. And that the state is proceeding on the lesser included of driving while intoxicated with a result of 0.15 or more. As a Class A misdemeanor, the range of punishment is up to 1 year in the Bear County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Did you intend to do that?
Yes, Your Honor, I'm sorry.
Counsel, has your client been able to provide you with any defenses?
Yes, she has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I do.
Ms. Cox, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of DWI as a Class A misdemeanor. They're asking that your punishment be assessed at 1 year in the Bear County Jail, and they're recommending community supervision. Did you understand that to be the plea?
Yes, Judge.
Defense?
Yes.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 80 hours of community service restitution, the DWI intervention course, DWI victim impact panel live, regular UAs, or the alcohol patch, 2 years driver's license suspension, and ignition interlock for half the term. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the lesser included offense of DWI with a reading of 0.15 or higher, how do you plead? Guilty, not guilty, or no contest?
No contest, Judge.
State any evidence.
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection, Judge.
State you may continue to confer.
Thank you, Judge.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge, we're just, we're thankful that we've been able to resolve this case. We're asking the court to accept the plea bargain.
All right. So other than the child that's mentioned in here, do you have any other children?
Yes, Your Honor.
How many?
I have 2 biological and 4 stepchildren.
All right. So what have you been doing since you have had this case pending? Have you gone to any type of treatment, any sober support meetings?
No, I started out with AA, but I didn't really like the way it went and how it was ran. So I went online and I got online groups and I just quit and
And there were, excuse me, Judge, if I might, there were some issues going on in her personal life that she was dealing with, and those thankfully have been resolved, and she's in a better place. And so we fully expect that she's in a position to be successful in probation.
Okay. All right. And are you employed?
yes, ma'am.
What do you do?
I'm a customer service representative. I work at Circle.
studio microphone, and that final condition, no contact with her own husband, that's huge. It tells you the judge sees potential volatility behind the scenes. This wasn't just a legal battle, it was a family situation with real risk factors. So now the question is, when this goes to trial, which version of the story survives?
Okay,
For right now.
all right. This is what the court is going to do. Well, before I do this, have you ever had any type of treatment for anything, mental health or anything of that nature?
No.
All right, I'm going to sentence you to 1 year in the Bexar County Jail. That will be probated for 2 years. And what is the court cost for a misdemeanor Class A, please? No problem. There's going to be 80 hours of community service restitution. I'm going to order parenting classes, and that can be with rainbows. And then the community service hours will be deemed satisfied. There's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to want a TAP evaluation. That can be done out of custody and follow TAP recommendations. If TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. I'm going to want 90 sober support meetings in 90 days. Regular reporting by Zoom or in person. Random regular UAs. And probation with the random regular UAs, if you'll just note she has a job, so there may be some issues. DWI intervention. DWI victim impact live. 2 years driver's license suspension. Ignition interlock for half the term. Probation, is there anything else?
Judge, probation wanted me to bring up that she does live in Medina County.
Okay,
She lives in Castroville.
all right. Is there a need for a transfer then to Medina?
It's a list. We can monitor, but I did want the court to be aware the field visits
Okay, all right, thank you.
unless she's transferred.
Okay, so we'll allow you to continue to live in Medina. And what's the court cost?
Or 90.
$490 for misdemeanor. It's only $300 for felony?
Well, this is because it's everyone.
Okay. All right, so the court costs of $490. Will you be able to pay that over installments? They're not going to ask for it all at once.
Yes, Judge.
Okay. All right, is there anything else you need from the court?
No, Judge.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
I think that's Judge.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing, and I'm not just saying this is because this is Texas, this is anywhere. But I know you've had a chance to read the police report. When you're following people and people think, why is this person following me? You know what ends up happening? Anything could end up happening. It could turn into a Lifetime movie. You know, people could get shot and then you're shot, your child's in the car. You understand?
Yes, Judge.
All right, good luck to you.